Mary McCord had a career as an established senior national security prosecutor in the Department of Justice before helping to start a new institute at Georgetown University Law Center dedicated to constitutional advocacy and protection. Her daughter was also a student at UVA, and Mary was outraged by the violence that occurred in the city and what it represented more broadly about the state of our state. And she will tell you about the powerful venture she launched aiming to reclaim the state from intimidation and violence that we're seeing today, which is another example of innovation against extremism. Again, the thesis that we are here about is that just as extremism has emerged from within democracy, democratic norms and institutions can and must be marshaled to overcome it, and that is the work of leaders among leaders, and that is our topic today.
I'm going to tell a very different kind of story about a different kind of tool. I think one of the things we're going to learn throughout the day today is that conversations are very important. But sometimes we need to use a blunter tool, and that's a tool that we used in Charlottesville after the Unite the Right rally. Everybody here, we've talked about that rally last night. We've talked about it this morning. Most of us were glued, really horrified to our televisions on August the 12th, 2017, as we watched what appeared to be battalions of neo-Nazis, neo-Confederates, white supremacists, and this new thing called the alt-right, which was composed largely of young white men in white polo shirts and khaki pants, hardly looking like the skinheads of former times. But we watched them literally invade the streets of downtown Charlottesville. A beautiful, quaint little college town, if you haven't been there, with a vibrant pedestrian downtown, local shops and businesses, fantastic restaurants, really good brew pubs, not that I would know that. And just literally march in as though they owned the place, as though they were going to war. And on that day, glued to my television, I had a son I was getting ready the next weekend to take back to school. I had a daughter who was going to be starting there. I heard commentators saying, you know, well, we have the First Amendment. It protects their right to speech. And the Second Amendment protects the right to bear arms. And Virginia's an open carry state, so what can you do if people have weapons? And I thought, that's not the First Amendment I'm familiar with. I went back to my colleagues at a very small fledgling institute we had just started. We were 3 attorneys at the time at Georgetown University Law Center. And we said, you know, the First Amendment, it protects the right to speech. It protects the right to expression. It protects the right to association. It does not protect the right to do violence, to incite violence, to threaten violence. The Second Amendment, it protects an individual right to bear arms for one's own individual self-protection, but it says nothing about the right to organize together with others to form your own private militia and invade a town subject to no public accountability whatsoever, deciding only for yourself when and where to use lethal force. The Second Amendment says nothing about that, and the Supreme Court has told us so. So we started thinking, well, what can we do? And on the Monday after that rally, I went on to a blog called Lawfare. It's a great legal and national security website, and I commend you all to it. And I went there to write about domestic terrorism, which we talked about last night, for those of you who were here last night. But on my way to making sure no one had already written about the domestic terrorist James Fields, who had plowed his car into Heather Heyer, killing her and injuring many other people, and is on trial right now today, as we speak, in Charlottesville Circuit Court, I wanted to make sure no one had already written about that, and on my way, I saw an incredible story by Philip Zellico. He's a University of Virginia history professor, but also an attorney and a former civil rights attorney who had worked with the Southern Poverty Law Center back in the early 80s to bring cases, litigation in both Texas and in North Carolina using state anti-militia, anti-paramilitary activities laws to get court orders to prohibit the KKK from engaging in its paramilitary activity. Let me unpack that just real quickly. In Texas, the militia wing of the KKK was actively threatening and harassing Vietnamese fishermen. We are right now still in just the years after the Vietnam War. Communities of Vietnamese had settled in some of the areas with good fishing in Texas, and this apparently was not okay with the KKK. And these groups were threatening them, burning effigies of Vietnamese fishermen, showing their armed force that they projected the ability to use against the Vietnamese fishermen. In North Carolina, the armed wing of the KKK was doing the same, threatening and abusing and terrifying African Americans because of their race. These cases were successful. And in the 80s, they resulted in court orders barring the militia wing of the KKK from engaging in this paramilitary activity. And from Philip Zelikows' post, an idea was born. We started, the three of us, and we gradually grew, added more attorneys to our small team, started researching the law. And it turns out that in Virginia, in fact, the Constitution has a clause that says, in all cases, the military shall be under the strict subordination of the civil authority. That means no private militia groups. There's also a criminal statute that bars paramilitary activity. It says you cannot assemble with more than two or more people for the purpose of instructing, training, demonstrating, or practicing the use of a firearm, explosive device, or any technique capable of causing injury or death for use during or in furtherance of a civil disorder. And we thought, well, that seems a lot like what we saw that day, because we saw the alt-right, the neo-Nazis, the neo-Confederates, maybe not with firearms, but they had their shields, they had their helmets, they flew their banners like battalions of yesteryear. They coordinated themselves together, they marched together, they had bats, batons, and clubs. They even organized themselves into phalanxes where the men with shields would be lined up together and men with flagpoles that were dual purpose with pointy ends would use those as the spears to go in between the lines of the shields. And they used them, as we saw when we reflected and viewed hundreds of hours of video and talked to people on the ground, that they used these as an offensive weapon to ram into counter-protesters. We have video of, an order, for example, by Michael Tubbs of the League of the South, "Let's go," as his entire force deploys into the counter-protesters. That seems like paramilitary activity to us. And at the same time, they seemed to be actually guarded, not so much by the police, but by an armed militia that looked and acted just like what you would expect to see from the National Guard. We're talking full military fatigues, helmets, tactical vests, combat boots, AR-15s, sidearms, radio communication, deployed at Emancipation Park, which is the park where the rally was scheduled to take place, deployed at specified intervals on both sides of the streets at the south end of the park, watching and keeping eye, as though they had any authority whatsoever from the state to be there. But everyone thought they did. They looked like the National Guard. They acted like it. They ordered people around. They put themselves in between protesters and counter-protesters, all completely outside the authority of government. These are the self-designated militia, the Pennsylvania Lightfoot, the New York Lightfoot, the 3% People's Militia of Maryland, the Minutemen of Virginia. None of this was authorized. So we decided to bring a lawsuit. And we started coming down to Charlottesville, first meeting with local people who'd been there to learn what happened, then meeting with local small businessmen that owned restaurants and shops, to see how they felt. Would they sign on and be plaintiffs in this lawsuit? Neighborhood associations who had literally had neo-Nazis marching through their yards on the way to get to downtown. Would they be interested in being plaintiffs in this lawsuit? And finally, the city. I got a chance to talk to Mike Signer, who was the mayor at the time. He introduced me others, met with the different council members, and the city was ready to sign on. And you might say, now, wait a minute, what are they signing on to? Well, you might recall that in the immediate aftermath of the Unite the Right rally, its organizers, Jason Kessler, Eli Mosley, Richard Spencer, David Duke, and others, Matt Heimbach, were pronouncing it a huge success. They had stepped off of the internet and out into the physical space. They were real, they existed. They were not just memes on social media, trolling people and spouting their hatred. They were a physical presence to be contended with, and even though ostensibly they were there to protest the city's decision to take down the Robert E. Lee statue, that's not really why they were there. They wanted to show that they could occupy space, just like a real battalion, just like a real insurgency. They could take it physically by force, and that they could actually advocate for an ethno-state. They were touting this, what a success, and they were already promising to come back. They were already promising, Charlottesville, we're going to come back over and over and over again. So the reason we thought we needed a lawsuit was to get a court order to say, you can't come back and do that. Use these state anti-paramilitary statute and the state constitution as the legal basis for the lawsuit to seek this court order. And so that's what we did. The city council, exactly 2 months to the date after the Unite the Right rally, voted unanimously by resolution to join the lawsuit. We together walked down to the courthouse and filed it. Then we set upon serving 23 different defendants. We had individuals, Jason Kessler, Eli Mosley. We had organizations, Vanguard America, Traditionalist Workers' Party, League of the South, National Socialist Movement, which is the American Nazi Party, and each of their leaders. And we had the self-professed militia, the Pennsylvania Lightfoot, the New York Lightfoot. And you know what else we had? We had a left-wing militia, the Redneck Revolt. Redneck Revolt we hadn't even been aware of until we started talking to people who had been at the rally. And Redneck Revolt had deployed to a park, not Emancipation Park, but a park a couple of blocks away where counter-protesters had obtained a permit in order to do counter-programming. And they had deployed there to provide protection for those counter-protesters. But they, even according to their own website, call themselves an anarchist armed community defense organization. Their goal that day was to protect the counter-protesters from the white supremacists and to create an autonomous zone where the police would not be allowed in. And they did this while fully armed. AR-15s, by their own account, they deployed fire teams on 3 sides of the park. The 4th side has a building on it, didn't need to be protected. And they would surge as a threat approached in order to fend off that threat. Again, no authority from the government, no public accountability, and leaving it really unto themselves when they would deploy these AR-15s and use lethal force. So they were named in the lawsuit as well because the lawsuit was content neutral. What we knew we couldn't do is say, Nazis, you can't come back and spew your hatred. Our First Amendment protects that. We're going to talk about that one of the panels this morning. And sometimes in these times of such dissension and discord and hate-filled rhetoric, I think even people that are pretty liberal will sometimes say, maybe I'm not so happy with that First Amendment right now. Can't we prevent that kind of speech? And the fact is, our Supreme Court's been very clear, going back to the Nazi marches in Skokie. Our Supreme Court's been pretty clear. You get to spout your hatred. But what we don't have to put up with is you doing it while armed in battalions and with violence. That's what we thought our lawsuit could do. That's what we thought it could stop. And just, without going through every detail, it was a success. We served a process on 23 different defendants in 11 different states. Some of them defaulted. Some of them struggled to find attorneys. And fairly early on, and many went out and on public media, excoriated us for filing the suit, excoriated the city for joining it, excoriated the businesses for joining it, said we were violating First Amendment rights, said we were violating Second Amendment rights, said this suit was violating the state law that says localities can't regulate firearms because the result of a successful suit would be that people couldn't bring their firearms back and as an organized militia. and also said we couldn't really sue under criminal statutes and directly under the Constitution on behalf of private parties for a civil injunction. But that's a big law school thing we can talk about for those who are interested. But bit by bit, and one of the things we wondered about with these militias, the militias, they really went out saying, we're going to fundraise, we're going to get lawyers, we're going to fight this all the way to the Supreme Court. And we wondered, would the NRA come out and represent them? What lawyers would they get? And do you know, they went and fundraised, and they couldn't find a single lawyer to represent them in this case. Eventually, I met personally with 4 of their leaders in Charlottesville, and they said, Mary, we will enter a consent decree. We will agree to the very court order that the plaintiffs want in this case. We have no intention to come back to Charlottesville. We don't want to be associated with Jason Kessler. We don't want to be associated with the Unite the Right. Now, these are people that had claimed all along they weren't ideologically associated with the far right, that they were just there to protect First Amendment rights. But if you dig a little deeper into their own social media postings, you might doubt that. But the fact is, they came forward and they said, we'll sign that consent decree, we'll have the court bless it, and we're not coming back. And so we took that. We talked to the plaintiffs, we talked to the city, they agreed, yes, let's take that. Bit by bit, others did the same. League of the South, they said, you know what? We don't want to come back to Charlottesville. We don't want to have anything to do with Jason Kessler. He's not really about what we're about. We're about flying our Confederate flags out in, the medians of highways and, waving our flags at people. But we don't want to be part of this again. And they signed the consent decree. And ultimately, all but 2 signed this consent decree before we were ready to go to trial. The consent decree was essentially a way for us to resolve the case with the defendants by them agreeing to the very relief the plaintiffs sought. So by these agreements, the individuals and the organizations and their successors are bound to permanently not return to Charlottesville as part of a unit of 2 or more people acting in concert while armed with anything, firearms, shields, any item that was designed to be a weapon during any rally, demonstration, protest, or march. Happily, in Charlottesville, Judge Moore realized we needed to get to trial before the 1-year anniversary because by the spring of 2018, Jason Kessler was already announcing Unite the Right 2 on the 1-year anniversary. The judge set us a trial date of July 30th, just 13 days before the anniversary. But 2 weeks before that, he issued an important legal ruling because we had gone into court and we had said, this doesn't violate the First Amendment, this doesn't violate the Second Amendment, this doesn't violate the state firearms preemption regulation statute. This doesn't violate this. We have a cause of action here. And the court issued its ruling the middle of July agreeing on all of these things, saying your lawsuit can go forward. Within 2 days, the 2 remaining defendants, Jason Kessler and Redneck Revolt, signed those consent decrees. Court ordered them. They are part of the record now. One last comment I'm going to leave you with, because I know we're way about, oh, actually I have 2 minutes, Mike. No, I don't have 2 minutes. No, I'm shaking my head. Okay, so one last comment. As a result of this lawsuit, we did, and my colleague Amy is here with me, we did a 50-state catalog. 48 states have this provision in their constitutions. It was started in Virginia in the late 1700s because they didn't want rogue militias. 25 states have the paramilitary activity statute that Virginia has. It was developed by the ADL in the late 70s, early 80s, and promoted as the KKK was starting to open training camps around the country. 28 states have a statute that prohibits private militias from organizing, drilling, or parading in their statutes. It dates back to post-Reconstruction, right after the Civil War, and has been upheld by the Supreme Court. These authorities are there, they exist. We sent our report out to all 50 state attorneys generals. We've consulted with other cities, many who've sent representatives here today. Murfreesboro, Tennessee, Adam Tuckish here from the city attorney's office, Burke Nelson, Eileen Park from Portland, Mayor Arguin from Berkeley. These are tools that can be used not necessarily to file a lawsuit, but as legal support for time, place, and manner restrictions that you can put on protests and rallies to protect First Amendment rights while protecting public safety. Thank you.